All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is a time set for oral argument in Kenneth Kestenbaum versus Diego Flores et al., our case number CV150161. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time. If you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask that those in attendance make sure your cell phone is off so that arguments are not interrupted. We've reviewed the briefs and conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. We're also getting a little bit of a late start, and I apologize to all of you for that. Our proceedings are being recorded and will be posted to YouTube in due course, so please, as you begin your argument, please state your name and the party that you represent. With that, Mr. Abney, you may proceed.
Thank you, Your Honor. May it please the Court, my name is David Abney, representing the appellant. We briefed quite thoroughly the special value to owner damages issue and the punitive damages issue.
Let me ask about that.
Sure.
That seemed to be in the complaint tied to the claim intentional infliction of emotional distress, which was voluntarily dismissed. Why didn't that go away with it?
Because there was a general claim for damages as a result of what happened to the dogs, and that would leave into the damage to the owner that the dogs had a special value. It was more than just intentional infliction of emotional distress, which is, we know from the pet bird case, the Kaufman versus, one of my petition for review disasters. But we know from that emotional distress is not available for the loss of a pet through malpractice or other means.
Okay.
But
so you see it as a separate general damages as opposed to one that was tied to a claim that was voluntarily dismissed?
Yes, Your Honor.
Okay.
And just a couple then words on special value to owner damages. In this case, dogs have a unique value to their owners, companionship, protection, and sometimes service. We all laugh at the little chihuahua that barks its head off when you come to the door. But that dog is performing its function of trying to protect the family that it belongs to. There are a lot of things that dogs do for owners that are far more than simply being there. They give so much more back for the little amount that it costs to take care of them. But, and as interesting as those damages are, and as interesting as the punitive damages issue is, they don't matter a lot if I can't get back into court on something. And I believe that there are three somethings I can get back to court on with the court's blessing: trespass to chattels, the fraud, and the professional malpractice. The professional malpractice thing came up on the third day of trial. Right at the end of the trial day, the expert was testifying about causation elements, and for some reason did what we have all experienced as trial lawyers with experts, forgot to use legal language that he had used properly in the deposition to say that it was more likely than not that if the diagnosis had been made earlier, the treatment would have prolonged Ozzy's life. And that's all he needed to say on the Ozzy issue at the trial court. And for some reason, the expert could not simply get that out. He started talking about hopefully this and we wish and all these other words.
I thought even at deposition, if I may be mistaken in this recollection, I thought even at deposition that Dr. Imsler,
yes,
is it? The plaintiff's expert had acknowledged that he couldn't say to a reasonable degree of medical certainty, in regard to the dog Ozzy, couldn't say whether Ozzy would have lived if Dr. Flores had adhered to the standard of care.
There was some initial prevarication at the deposition, but he finally got out the opinion, and it's in his deposition at page 69, lines 2 to 8, which was Exhibit M to Index of Record 133. It's also cited a couple of times in the briefs. He said, had the diagnosis been made earlier, it is more likely than unlikely that treatment would have prolonged Ozzy's life. Now, the prevarications and the waffling at trial and during the deposition is something that really goes to the weight of his testimony. You can argue to the jury at the end of the day that this is not the greatest expert in the world. He was not as forceful as you would like in a situation like this, and therefore you should downplay the weight that you give to that expert. But that doesn't mean to throw out the expert's opinions entirely. This is one of those areas where the jury has a huge amount of say in what happens.
The question is whether the claim gets to go to the jury, if the expert testimony is required on causation, which it is.
Right.
And the expert says yes at one point and no at another. Your argument is it goes to the jury.
It goes to the jury to determine the weight. And if in a situation like this, if the expert, even if you pulled out the deposition and say, didn't you say this, which the lawyer didn't get a chance to do, he was cut off as he was trying to deal with the situation. But even if you pull out the deposition and say, didn't you say this, and he says, well, I didn't mean it at the time, or some sort of waffle at that point, then you have the right to say, well, this is what you said under oath, after due consideration of the evidence and going through all of your investigation in the case. This is what you said, is it not? I think you'd have the right to impeach your own expert and get the evidence in that way, at the very least, because this is critically important to Ozzy's case. Now, for Comet, the expert had already said, well, it was below the standard of veterinary practice not to have diagnosed this allergic condition earlier, not to have done proper tests that would have revealed the allergic condition earlier, which was treated in a matter of a week or so by the second veterinarian, and it cleared up. It was all gone. But what happened when the judge decided that the expert opinion on Ozzy was bad? Then the baby went out with the bathwater, and any opinions about Comet were gone. The judges said, and I wasn't there, but I could read from what I read of the transcript, the defense lawyer was surprised. He says he started to make a motion about Comet, and the judge says, well, the whole case is done, and the lawyer saying, the whole case? And the whole case, yeah, the whole case is gone, and it really should not have been gone when you talk about the professional malpractice. Because there were opinions about Comet that the expert had successfully given. There was also a considerable amount of background information of timing that would really bolster the expert's opinion about Comet, that the fact that they got the new veterinarian, you got the testing done, and you had a new diet for the dog, and the ear problem cleared up. So in professional malpractice, there was enough to have gone to the jury on both dogs and to have the jury decide what to do.
Well, wasn't there testimony, though, from the California vet that suggested that even if the lymphoma had been earlier diagnosed and treated with chemotherapy, then the dog may have died earlier?
That's a possibility. But you had the direct testimony from their expert that the dog, more likely than not, the dog would have lived longer. And all you have then is a clash of experts. And that's what the jury deals with all the time, clash of experts.
What are the damages recoverable in a professional veterinary medicine case?
For this kind of case?
Yes.
The medical bills that you pay, the veterinarian bills that you pay that you should not have paid. For Comet, for instance, month after month after month of eye drops, that had nothing to do with curing the allergy to food. And then for the lymphoma case, then extra months of treatment, concern, and disability for the dog. If the dog had gotten better treatments, the dog would have been in better condition.
You used the word concern. Is the owner entitled to recover emotional distress kind of damages?
Well, no, I'm not going to step into that minefield. But the owner is entitled to get.
Not terribly clear to me. It probably should be, but.
Yes, no, it really is a part of the special value to owner kind of damages. And it's an interference with what the dog can and should be doing. The dog should be providing companionship without being constantly in pain, having nausea and diarrhea and all these other things. The dog should be able to provide the protection services or whatever services the dog would provide, even if it's going to just get your slippers at the end of the day and bring them to you, or go out in the morning and get the paper, whatever it may be.
I realize I probably asked a question that's not pertinent to the precise issues on appeal, but I was curious.
No, if you ask a question, it's pertinent as heck, Your Honor. I'm sorry.
No, not always. If it were only true.
Yeah, well, which if I may segue into trespass to chattels briefly, It's an odd tort. It goes back a long, long way. You go and steal your neighbor's cattle. In fact, the word chattel, I traced it back on my iPhone this morning, goes back to the Latin word for cattle and the Middle French word, and eventually it became a word for slave, like an Anglo-Saxon slave, and then it became to apply to property of any kind. But it really, if you went out and stole your neighbor's cow, you would have conversion. But if you went out and beat your neighbor's cow or poisoned your neighbor's cow or even just chased your neighbor's cow, then you have committed trespass to chattels. You have interfered with, you have intermeddled with the right of ownership and possession that you have. So it goes back a long, long way. As I noted in the briefing, it's had a huge revival in recent years as a way to deal with spam for emails and other electronic attacks, malware and whatnot, on your computer by somebody else. And it's sort of odd because, as I guess Justice Stewart said in one of his opinions, all you're talking about is electrons that are invading your property, your computer, and interfering with your use of your computer. If it's a spam attack, for instance, you've got a drawer full of emails that have clogged up your system and you can't use it. But as I said, it goes way back. It's still a good tort. And here there was intermeddling and interference because improper treatments were being given.
Well, but wasn't there consent? Voluntary consent. Though it was, the medical care may have been ineffective. He didn't stop and then take it to another vet who said, "Oh, I know what this is."
There was consent to veterinary care, but there was the consent that's given. I don't know if it's obvious or not, but the inherent consent, the implied consent is, I consent for you to treat my animals in a competent and professional way. And if all you're doing is lying to me and misrepresenting to me what you are doing, and that you are knowledgeable and know what you are doing, and as a result you were interfering with my ownership, possession, and enjoyment of my property, then that should be regarded as a trespass to chattels. The consent is...
Oh, that almost sounds like at least the argument for more like for the fraud.
Well, it edges into fraud, which is one of the bases here. When you talk about the fourth element of fraud that we briefed, that whether the doctor knew or should have known that he was making misrepresentations to the owners of the dogs, and he should have indeed known that what he was doing was not proper, was not helpful, was not dealing with the problems for both animals. For Comet, it was distressing, of course. You'd have a dog with an ear problem would just drive you nuts because you can't really communicate very well with the dog. How are you feeling today? Is your ear hurting? You have that sort of problem. And with Ozzy, it's a horrible situation. You've got a very, very sick animal that's not getting better, and you're being assured that, with proper treatment, this isn't lymphoma, this is something else.
Do we know what the dog died of?
Lymphoma, cancer.
Really? As
Yes.
opposed to anything else?
That was it, as far as I understand.
Not the chemotherapy?
No.
Not the other stuff that the dog had ingested that was found?
My understanding is that it was the cancer. But
Where's that evidence in the record?
I'll take a look, see if I can find it. If not, I'll supplement with the court later and see if I can identify where in the record. But my understanding has always been it was the lymphoma that killed the dog.
Are we on the fraud count now?
We were on trespass to chattels and edging into fraud. But let's go back to trespass to chattels, if I may.
Because I thought I heard you say something I want to talk about when we get to fraud, but I can wait.
Well, as far as trespass to chattels, it's really, as I said, a very old tort. I cited a lot of old reference works and treatises because the tort hasn't changed over the intervening time, and they really set the basis for it.
Have there been any? There's lots of treatise representation. I didn't see necessarily any cases outside of the Washington case where they kicked out the med-mal, but said the court should have allowed the others to go forward without addressing any substantive basis for that.
I'm not aware of others at this point. I know there's been a great deal of literature in the veterinary area about trespass to chattels and dogs, and an enormous amount, as I said, surprising enough, in the computer field. But I think the trespass to chattels common law still is with us in great strength. Fraud. The first part is the fourth element is the one that deals with what you knew or should have known, that you were providing inadequate care, that you were
Well, it's
that you were providing representations about what you were doing that were false.
well, the knowledge of its falsity or the ignorance of its truth.
Right. And if as a veterinarian, if you're spouting off to if you are communicating with the owner of the animal and saying, well, I know what is best for this animal, and these are the treatments that you should follow, and we don't need to do any more tests. This is all you need to be doing. You are making misrepresentations that you know or should know are false.
I guess this is the question I wanted to ask that you and Judge Portley have just touched on here. You've used the phrase know or should know, and we have that in lots of things in the law, of course, but the 9 elements, classic 9 elements, as I understand it, it is the speaker's knowledge of its falsity or ignorance of its truth.
Correct.
Are you're equating should know with ignorance of its truth? It sounds
Yes, Your
like.
Honor. Yeah.
I'm not sure those are the same.
It's very close. I think it's in this particular setting, and I believe that the cases and treatises have dealt with it, is a know or should know. The ignorance of its truth is you are saying things without really knowing what you're saying. And you shouldn't do that. You should at least investigate to make sure that you're on a sound footing, especially when you're dealing with something of this importance. This veterinarian
You can't always know you're right, can you?
No, you can't.
Especially in medicine or veterinary medicine?
Absolutely. But in this case, he should have known. And the expert was pretty good on this, that he should have conducted tests on the lymph to find out if there was lymphoma. He should have investigated further. He should have conducted ultrasound. He should have done a whole number of things and did not do them. The problem with the expert was not so much the standard of care, it was that causation element, more likely than not. And then the last element for fraud is the hearer's consequent and proximate injury. Here it was the ineffective care for Comet, the misguided care for Aussie, the additional expenses, and of course the interference with the ownership and enjoyment of both animals. Judge Portley, may I assist?
No, not yet. But
Okay.
thank you for.
Well, if I may reserve my time.
Very well.
Thank you.
Thank you, Mr. Evans. Mr. Stoll.
Good morning, gentlemen. David Stoll, appearing as counsel for the appellees in this case, Dr. Flores, his wife, and his professional practice. As you've heard, this is a veterinary malpractice case, which may be something unusual for this court. My client, Dr. Diego Flores, is a licensed veterinarian who provided veterinary services to 4 of the plaintiffs' dogs over a 14-month period of time. The claims involving 2 of the dogs were voluntarily dismissed by plaintiff before trial because, and this is extremely important in this case, the plaintiff certified at the outset of the case that his claims were subject to ARS Section 122602. Specifically, he certified that expert witness testimony would be necessary to prove his claims. I just heard opposing counsel say to you that, well, we should leave that should have been left up to the jury. Well, that's not true.
What I think he was saying was that if the testimony isn't as clear as it should be, but he otherwise says something akin to, I think it's causation, then the jury gets to weigh that.
We didn't get there in this case, and I was present during the trial, and the expert was crystal clear that he could not testify to causation. All he could say with regard to Ozzy is that he hoped the dog would live longer. And the appellants, they're doing the best with what they have to work with, but they're trying to portray this expert as befuddled, confused. The word amnesia was used. This expert was crystal clear in his testimony, and he's not. Opposing counsel said something about he wasn't well versed in legalese. This veterinarian expert was not only a DVM, a licensed veterinarian, but he had a law degree too. The plaintiff's expert had a law degree. The testimony was clear on causation. He couldn't go there. All he could say is that he hoped Ozzy would have lived longer. And with regard to Comet, there were no opinions on causation whatsoever. So I'll get back to causation in a bit, but I want to address, there are 5 issues here on appeal, and I want to deal with them in the order in which they were presented. First, on the trespass to chattel claim, the trial court did not commit error in dismissing the trespass to chattel claims because at all times that Dr. Flores treated the plaintiff's dogs, he had temporary possession of them with the plaintiff's consent. In the plaintiff's opening brief, he correctly states that the tort of trespass to chattel is an outgrowth of the tort of conversion. Plaintiff cites the Percy Henry Winfield's textbook where it discusses trespass to chattel historically, and it says that traditionally it involved beating or killing chattel. That's not the case here. Dr. Flores was a veterinarian. He was providing care and improving the quality of care for all four of the plaintiff's pets. How do we know that? The plaintiff's own expert testified that the treatments that were provided were appropriate for the medical conditions that were presented and were effective. The sum and substance of the plaintiff's expert's opinion regarding standard of care is if I would have had that case, I would have done something more. He would have referred him to an expert or to a specialist in both cases. So again, the expert simply said that if he was treating the dogs, he would have done something more. It's undisputed in this case that at all times that Dr. Flores had possession of the plaintiff's chattel, his dogs, it was with his consent. And under Arizona law, consent is an absolute defense to a trespass to chattel claim.
What do you think of the argument that he wasn't consenting to ineffective medical treatment over a period of time, however we may determine that to be?
Two things. His own expert says that the treatments were effective. And second, it's this subjective belief that they weren't effective on the part of the plaintiff. That is the basis of that claim. In response to the consent defense, plaintiff claims, yes, I gave my consent to Dr. Flores to take possession of my pets and treat him, but the treatment results fell below my expectations. Well, even if that's true, the failure to get the results that you subjectively hope for does not constitute fraud and does not constitute trespass to chattel. A good example
might constitute veterinary medicine malpractice.
And for that, you need to have an expert to testify that the treatment fell below the standard of care, and most importantly, for purposes of today, that there was a causal connection between the breach in the standard of care and some type of harm.
You agree that the plaintiff's expert does satisfy the standard of care testimony requirement?
He says, with regard to the standard of care, that a reasonable, prudent veterinarian would have done something more. Right. And getting back to the intentional tort of that we were just talking about, it's passive negligence is what we're talking about here. We're not talking about an affirmative act that was done by my client that injured his property.
What about, are we back on fraud here? Or?
They kind of overlap, but I was still on trespass to chattels.
Okay, well, I'm sorry. I'm going to move you to fraud for a second, at
sure.
least, for a moment. What about Mr. Abney's argument that the knowledge of falsity or ignorance of truth is really this practical, as a practical matter, the same as knowing or should have known?
I've never heard of that before, because I think under the elements of fraud, all 9 of them have to be proven by clear and convincing evidence. It's not to be speculative. There's a higher standard of proof. And the actual element of fraud says, on the 2 elements that we're here today, there must be clear and convincing evidence of the speaker's knowledge of the falsity of the subject representation. There's no evidence of that in this case. Second, element number 9, there must be clear and convincing evidence that the false representation resulted in proximate injury. And in dealing with the fraud, the hardest thing that I've had in getting my hands on the plaintiff's fraud claim is what is he claiming was the fraudulent act. The plaintiff initially claimed that Dr. Flores committed fraud when he couldn't give definitive answers during his deposition to questions regarding his prior marriage, his immigration to this country, and aspects relating to the operation of his business. He was pointing to deposition questions. He argued in response to our motion for summary judgment on fraud that those deposition answers were vague and constituted a propensity for fraudulent behavior. That's not clear and convincing evidence of a specific act of fraud, a specific misrepresentation. There's no evidence that Dr. Flores knowingly said something, anything that was later proved to be false.
With respect to, at least as we see the complaint, as a result of treatment to the dogs.
Right, and that
of anything else that may have been going on.
right, and that's what the trial court, in ruling in their motion for summary judgment on the fraud, the claims that they were making of fraudulent behavior didn't relate in any way to the underlying treatment of the animals, and that's a necessary element that wasn't satisfied at the trial court level. Later, in response to the obvious defects in their fraud claim, they claimed that there was a suggestion that one of the medical records had been altered in the case. And by way of factual background, what happened is the plaintiff continuously brought his 4 dogs to my client for treatment. He only came once. The other times, it was either his personal assistant or his wife that brought the pets. On one of the occasions when the wife was there, Dr. Flores testified that he made an offer of a referral to a specialist, and he noted it in the record. Later, during the course of the lawsuit, the plaintiff saw that and said, I was never told about that referral. Well, his wife would have had to have told him that. He said, I was never told that. That document must be a fraudulent document, and that's the basis of my fraud claim. Well, there's numerous problems with that. There's no causal connection between a falsified document and harm to the pets. And so ultimately the court found that there was no evidence that the plaintiff sustained injury from Dr. Flores' alleged propensity for fraudulent behavior or testimony, nor was there any evidence whatsoever that Dr. Flores knowingly misrepresented anything to plaintiff as it related to the treatment of his pets. Let's move on now to the motion for directed verdict at trial. The plaintiff claims that
before you
go ahead.
Get there, Mr. Abney started out with his special damages. Do you see that element of damages as a general claim, or was it connected to the intentional infliction of emotional distress?
It was pled as a general damage claim. It survived the professional malpractice claim when the trespass to chattel and intentional infliction of emotional distress was, I believe, voluntarily withdrawn by the plaintiff. The intentional infliction of emotional distress was. If you wanted to talk about...
So it would have still remained if the court had not directed its verdict as it did.
Correct. It would have been an element of damages under the professional malpractice claim. And briefly, as long as we're talking about damages, and especially the emotional distress damages, pardon the pun, but the Kaufman-Langhofer case is on all fours with the situation presented here. Factually, the cases are virtually identical. We have a plaintiff suing for veterinary malpractice and wants to include a claim for emotional distress damages. This court, the Court of Appeals, ruled in Langhofer versus Kaufman that a pet owner is not entitled to emotional distress damages for the injury or death of their pet. End of story. Getting back to the motion for directed verdict on the professional negligence claim, the motion for directed verdict was justified because plaintiff's expert did not forget his original opinion on causation. He changed his testimony. And if you look at his original affidavit, again, this case is governed by ARS 122602. The plaintiff's expert prepared a preliminary expert opinion affidavit, and on causation, he said, this is relating to Ozzy, the dog that died, we don't know the cause of death. There is nothing in the record that says what the definitive cause of death was. The subsequent treating vet testified that she doesn't know that it's entirely possible the chemotherapy could have killed the dog. The dog had cancer for which there is no cure. The plaintiff's experts, all the experts agree that there is no cure for this type of cancer. If the chemotherapy killed the dog, then the alleged negligent act on behalf of my client, a delayed diagnosis, that may have prolonged the dog's life if it was going to die from chemotherapy. Also, as you pointed out, the physical examination after death, which didn't determine the cause of death, found that the dog had ingested foreign objects, and the independent veterinarian, the subsequent treating vet, said that may have caused or contributed to the dog's death. But getting back to the causation opinion, preliminary expert opinion affidavit on Ozzy, Dr. Emsweiler said, had the diagnosis been made earlier, it's more likely than unlikely that the treatment would have prolonged Ozzy's life. That's what he said in his affidavit.
It's more likely it would have prolonged.
Yes. But that's what he said in his affidavit. Then as the case goes on, after he's heard the testimony of the subsequent treating vet that there's no definitive cause of death, after he sat in the trial and heard, perhaps for the first time, my client testify, heard my client's version of what happened that wasn't filtered through the plaintiff or his counsel, his testimony changed. And he testified at trial, the most he would say is that hopefully Ozzy would have lived longer. Hopefully. That's a mere possibility or hope. That's not causation. That's not more probable than not. In the face of that testimony, Judge Whitten was dialed in on this too. He took it upon himself to ask follow-up questions to this expert. And these are cited in the brief, but Judge Whitten stopped and said, when you say, I'm sorry to be picky with you, but when you say the animal would have hopefully not gotten lymphoma and lived longer, can you say that he probably wouldn't have gotten lymphoma and he probably would have lived longer? Dr. Emsweiler said, no, I can't say that. The appellant is critical of the trial judge.
But nobody objected to that as a compound question, huh?
Well, the judge was asking the question, so he would have to.
I don't care.
He would have to rule on his own question. Next time I'll do that. The appellant is
You may
critical.
not like the answer, but you can protect the record. Nothing wrong with that.
But in any event, the appellant is critical of the trial judge for failing to provide trial counsel, plaintiff's trial counsel, an opportunity to impeach his own expert witness. And nothing could be further from the truth. Not only did the court allow appellate's trial counsel the opportunity to impeach his own expert, but he actually did. He impeached Dr. Emsweiler with his prior causation opinion in his affidavit. It's in the record. The expert, Emsweiler, was on the stand and was handed his prior affidavit opinion on causation by plaintiff's counsel and asked him to read it. Then he said, now, Dr. Emsweiler, now that you've seen this, does this refresh your memory and change your trial testimony? Dr. Emsweiler says, no, it does not, meaning no, it does not change his trial testimony.
So the witness on the stand in front of the jury read to himself the affidavit, and it was used to refresh recollection, not as a prior inconsistent statement.
Correct.
So the affidavit itself, the substance of the affidavit itself, was never admitted at trial.
I don't believe so.
And the same, I'm assuming, without having a picture-perfect memory of his deposition, that at some point in time at his deposition he said more probably than not, and that was not offered as a prior inconsistent statement for use by its truth at trial either.
It was not.
Okay.
It was not. And counsel makes an argument that plaintiff's trial counsel was denied the opportunity to use the deposition. The deposition testimony is my questions about the affidavit opinion on causation. They're one and the same. So whether trial counsel, who did an admirable job on in trying to rehabilitate or impeach his own witness, whether he chooses to use the original affidavit or the deposition testimony is of no consequence. The bottom line is he was allowed an opportunity to impeach his witness. He did show him his prior causation opinion, but that didn't cause the expert to change his opinion. So at the end of the day, what we have is an expert that failed to render causation opinions for either one of the two dogs. And in the face of that, the judge did what he was supposed to do, which is to grant our motion for directed verdict. Now, in response, the counsel has made this claim that, well, there still was enough there for that to go to the jury. And that's not true because of the certification. ARS Section 122602, in certifying that expert witness testimony is necessary, one of the things you're certifying to, and this is on subsection 4 of the statute, says that the expert will testify to the manner in which the licensed professional's acts, errors, or omissions caused or contributed to the damages. The statute says that that testimony, that opinion regarding causation, has to come from an expert. The plaintiff can't, at the start of the case, certify, yes, I'm going to need an expert to testify on causation, and then at the end, when it goes up on appeal, ask you to overturn the decision, remand the case back because the jury should have decided something that I've already certified that only an expert can do.
I guess I wasn't perceiving the plaintiff's side here as making that argument. I perceive they are saying that this expert's testimony, though wobbly at times and different at times, had enough in it that the jury should have decided which statement to believe and which ones not to believe.
There was not, his affidavit was not admitted into evidence. As he was shown it and asked, does that change your testimony? And he said no. The causation opinion can only come from one person on the plaintiff's side, and that's his own expert. And the opinion that he expressed at trial is not wobbly, it's not convoluted, it's not confused. Again, this expert is a veterinarian, he has a law degree, he's knowledgeable. He testified unequivocally in response to counsel's questions and the judge that the most he could hope for with regard to Ozzie is that he hoped he might live longer. And he gave no opinions on causation on the other dog comment. So the Judge Whitten, I apologize, I see I'm out of time, but Judge Whitten did the appropriate thing, and the appellants in this case have failed to present any compelling argument for this court to overturn any of the decisions made by the trial court in this matter.
Thank you, Mr. Stoll.
Thank you.
Mr. Abney, rebuttal.
As far as Comet, the expert did testify at trial that Dr. Flores should have referred Comet to another vet or performed in-house or outsourced testing to diagnose and treat the allergic condition. That's in the trial transcript for December 11 at page 171. So there was testimony about Comet at trial, what should have been done. As far as Ozzie, when on page 263 of the trial transcript for December 11, Mr. Kestenbaum's trial counsel is trying to get an extra time to locate in the record the actual testimony. What he was thinking of, I'm sure, and what he was looking for definitely was the deposition excerpt that he could have presented to the court, and asked that be done, and the trial judge refused, just stopped him right there.
What page was that? Excuse me?
That's in the trial transcript, page 263 for December 11, 2014. It's on page 19 of the opening brief down at the bottom.
Was the expert, though, shown during his testimony, his prior affidavit?
I believe he was, Your Honor.
Okay.
But
again, used to refresh recollection
Right.
as opposed for substantive.
yeah,
evidence.
the critical thing, and the thing that we're all thinking of, is you've got to get it into before the jury at trial, that it's more likely than not that earlier diagnosis would have prolonged the dog's life. That's what you got to get in. And he was on the verge of doing it. He was telling the judge, I just need a little more time to do this, and the judge stopped it. It was the end of the day, of the trial day that day. We're getting on to 5 o'clock. There was no reason why not to give a short recess, or if you want to let the jury go home, then to go ahead and say, we'll pick this up first thing in the morning. Take your time and look through the record. I want to make sure that we don't have 3 trial days wasted and all the months and months of trial preparation and effort and discovery just gone poof because of this problem. And that doesn't explain why, other than sort of, this was a very emotional trial. And if you glance at the transcript, you'll see this very emotional trial. Other than a desire to just to end it, there was no reason not to let it go forward as far as comment. Of course, the other problems with the special value damages, punitive damages, trespass to chattels, fraud, all those had occurred earlier. And but here we are, the third day of trial. Why not? Why not just slow down a little bit?
But that argument, with respect to Ozzy at least, is abuse of discretion, right? That the trial court sort of moved too quickly. Is that part of your argument correct?
That part
Under Rule
is.
611.
Right.
Your argument that, well, wait a minute, we don't even get there because what this expert said, if you look at it right,
Right.
was enough to get to the jury. But if we look at it and it wasn't, then your argument really turns on a finding that the trial court abused his discretion in
Yes.
dealing with the motion for judgment.
Yeah, and that's the secondary argument. The primary argument is that there was a right to rehabilitate this expert. There was a right to bring out the testimony from the deposition.
Right, but the only way you get to that is if you show that that was denied by the trial court abusing its discretion.
Well, yes, and certainly abuse of discretion is the overwhelming cloud in the sky above what's going on here. But if you go through the transcript of just a few pages right at the end there really wasn't any opportunity to do more.
Let me ask you a little bit about, though, because I heard opposing counsel mention that really the affidavit is the driver and the deposition, was largely testing the affidavit. And the affidavit was handed to the doctor in open court, just used for a different purpose that didn't get the substance of it before the jury.
Right.
So the counsel knew where the affidavit was. There was no need to sort of go fishing for that.
Right. But I think the deposition testimony is really what's critical for the case, what really drives what should have been going on at the trial. There was an opportunity here to make sure the case went forward on the professional malpractice, and it should have gone forward, at least to the point of allowing the plaintiff to develop this as well as possible to the jury and face the barrage from the defense. Well, you've got the world's washiest expert possible. But the jury gets to decide what to believe.
Was the deposition marked as an exhibit? I can't remember that part of it.
I think it was, Your Honor, but I don't know if it was. I don't think it was admitted.
I know you addressed the dog comment in the start of your rebuttal comments, but was there a testimony of causation?
Yes, I believe that the fell below the standard of care, and then the causation was the sequence of events, which is clearly laid out in the trial transcript. That it went to the second vet. Second vet did some easy testing, and within a week or so, everything was fine. All it was required was a change of diet. And then the expert says you should have done it earlier. So I think you've got enough there that reasonable jurors could say, okay, we've got enough here, that it's below the standard of care and we have the causation. Time has fled, as it always does.
Doesn't mean that lawyers have the right to object to judges' questions.
Well, I've done it before, but you always feel awkward.
Risky.
It's very risky. But what the heck?
At least, yes.
Sometimes you have to.
Yeah.
Thank you.
Thank you, counsel. We appreciate your argument today. We appreciate your briefs. We'll take the matter under advisement. We will issue a ruling in due course. Thank you all. We stand adjourned.